This is San Diego. It has to do with 7612. The mother was married to the father at the time of Donovan's conception at birth, had an affair with David. Mom got pregnant. David didn't seek involvement until the child was 1. DNA test proved he was bio-dad. They stayed at David's apartment for 2 weeks. A dependency petition was filed after there was a DV incident. Donovan Sr. was named presumed, then David wanted presumed, and then he withdrew. The mother tested positive for methadone during her 301, then hydromorphone during other pregnancies. The court released Donovan to Donovan Sr. David wanted presumed status. Everybody appealed. The issues that mom did move, the issue was taking the child into his home. So mom had moved in with David for 2 weeks after marital problems, but unfortunately for mom, David locked her out when they were having an argument over custody. From there, the police were called and found about 50 pot plants in David's apartment and the child inside. Court of Appeal reversed and said, and I love this, they actually quote the agency, David is not the poster boy for application of the statute. He's not barred, but he basically withdrew his request. The courts here are to protect existing relationships rather than foster potential relationships. And this arises, 7612, for those of you who aren't that familiar with it, has to do with how many presumed parents can a child have. And it's a very new provision that I think has only been in effect for maybe 2 years. And so this is one of the very first published cases we have on it. It's not an open gate for every man who's ever seen the kid to come in and try and request presumed parent status. It's supposed to be able to protect existing relationships. It's not also for men who have had no involvement in their child's life, hear about the dependency case, and then try and jump in as a presumed parent. So they basically cut David out of the picture. I know, right? Adoption of TK came out of Orange County in 2015. This one is amazing. You really should probably read this fax because this one's a good one. The father stalking of mother and dishonesty negated any claim he had as a Kelsey S. father. And they actually said in the Court of Appeal opinion, children do not get fed and clothed on false checkbook entries. Basically, one thing to take away from this is, oops, I shouldn't have had a baby with you, crazy stalker. The Court of Appeal called father's actions, quote, downright creepy. Basically, mom and dad agreed to have a baby, and then mom said, but by the way, you probably should get a job, and he didn't. But once he did get a job, he deposited $200 into the baby fund. He eventually withdrew $160 of that. He did make phony entrants in his check register to show that he was repeatedly giving money to mother, but refused to turn over financial records until they were subpoenaed. He accessed her phone. He got the phone numbers. Mom at that point said, I'm giving this baby up for adoption. So he accessed her phone and got the phone numbers of the first couple that expressed interest in adoption, called them, let them know that there was no way he was agreeing to this, so they disappeared. Called the second couple that was interested in adoption, said she had used cocaine, marijuana, and alcohol during her pregnancy. When mom went to see an attorney, dad actually sent an email to that attorney while mom was there, asking the attorney to represent him, even though he had already retained counsel. He showed up at a medical appointment. So then he comes and tries to say, I'm just a Kelsey S. father. And the Court of Appeal said, no, you're not. You're downright creepy, is what they said. Again, here we have another case out of San Francisco very recently where basically it's like Oprah Winfrey on the bench saying, you're a presumed parent, you're a presumed parent, you're a presumed parent. And the Court of Appeal saying no. Here we have Joel, who's the biological father. When mom says she's pregnant, he basically says, I'm not really ready to be a father. Bye. Michael, when she was pregnant, she got in a relationship with Michael. Even though he was not the biological father, he signed the voluntary declaration. The case came in because there was oppressive, is the term the Court of Appeal used, DV between mom and Michael. Michael went to family law court. And then mom ends up in dependency court again with the stepfather, who pretty much has raised this child. The kid calls him daddy. He was there for potty training. He really is the one that has given the day-to-day care. Michael and Joel go to family law court to establish paternity. While they're there, the dependency court case gets opened, and this is a fact that's very critical for the Court of Appeal. The family court sets aside the voluntary declaration of paternity that Michael did, finds Joel to be the presumed father. Then one of them files a motion to reconsider. At that point, the dependency case is open. But I guess no one notifies the family law court that we now have a dependency case. And so the family court then basically says, okay, Joel and Michael, you're both presumed fathers. So then we get to dependency court, and Michael and Joel's attorneys give it, and the court says, okay, well, I guess I'm bound by a family law court, so now you're both the presumed father. And the Court of Appeals said no. Basically, can I put my other slide in here? Because I forgot to put it out. No, I didn't. I missed a slide, but I'll tell you the opinion, is that the Court of Appeals said no, that the family law court technically didn't have jurisdiction at the time because the dependency case was already open, and dependency court has exclusive jurisdiction over paternity from the date that case is open. And so the fact that the juvenile court used that as a basis to find them both presumed was not valid. And so what the Court of Appeal did is actually remand to have the court consider under 7612 which of these men, if any, should be the presumed father. Okay, review hearings. We had a lot of challenges to to 364 cases. This one has a long list of facts, but I'm just going to run through it really quickly. This is out of Orange County. The recommendation to terminate dependency jurisdiction is a strong indication that the agency did not attempt to prove that the conditions which justified initial assumption of jurisdiction still existed. And basically in this case, it was the juvenile court saying, I don't know, I have concerns, and basically said, I'm going to keep the case open. And mother filed the notice of appeal. So it really, to help us, it really does sort of ask the juvenile court to really give weight to the social worker's recommendation on whether or not to close a case. I'm going through some of these pretty quickly because the slides will give you a lot of the facts, and I don't want to run out of time. Okay, here's another one that you probably should star. Wait, hold on, I got out of order. Patricia W. versus Superior Court. This one came out at the beginning of the year. Out of Del Norte County, but it's no reasonable efforts made by a department in a mental health case. So we get asked this a lot for reasonable efforts, and here is one. Mom's case plan basically called for anger management, parenting, support systems, and to meet with a mental health clinician to, quote, help her not harm others, stay safe, and live happy. The juvenile court, at the 6-month review, the agency recommended termination of FR. Mom testified very well. The social worker testified that mom had completed a parenting class but should take it again. And the therapist, the social worker spoke with the therapist instead of her psychiatrist regarding her medication compliance and did not know if mom was taking her medication. The juvenile court still found reasonable efforts, and the Court of Appeal reversed. They do go through a lot of the prior published cases on mental health, so I do recommend that you read this one. The evaluations were not given as part of the trial record, the mom's mental health evaluations. They have good language from a case called N. Ray Tracy J. about an initial 730 evaluation not providing requisite detriment. The Court of Appeal found that mother was the most well-informed of anyone as to her diagnosis. Although the worker had suspicions mom was not on medication, the social worker didn't do anything to ascertain where it was true, other than saying she thought mom had some behavioral changes. And none of the services by the agency were specifically designed to address improving mom's ability, or improving the ability to ensure that mother was on proper medication. So it's a really good case to read if you have a mental health issue. Okay, DT versus Superior Court. I gave you the overview because this one is complex. Okay, out of San Francisco. Mom's been here, let's say, at least 9 years, right, by the time this comes. The original case came in 2005 because of severe burns. Then it was JT. Then mom passed out drunk on the bus with the children. Then there was a new petition. FR was terminated. She went to PPLA. Then the kids went to legal guardian. Then mom filed a 388. Jurisdiction reopens. Then there was a 387 against the legal guardian. Then the legal guardianship was terminated. Then it was HOP again. Then there's a new 300 petition on a new baby. Then mother becomes a mother and a grandmother. Then the mother meets the social worker smelling of alcohol. 387s and 300 filed. And then mom gets no FR. The court denies mom FR under B10 and the writ followed. Mother's attorney, because it's not LA, so I can say it because it's funny. Mother's attorney acknowledged she had received 31 months of services, but argued, quote, the past is the past. The Court of Appeal noted that guardianship was the permanent plan, but later failed, which brought 366.3 into play. Borrowing the reunification provision under 366.3 conforms to legislative intent. It's a little procedurally wonky because they vacillate between 361.5 and 366.3, but they basically said that the court had this discretion to give mom more FR under 366.3, but given this record and given mom's history, they didn't have to do it. And it was only if unique circumstances suggest it's the best alternative. But certainly mom, removal from a parent under 387 does not entitle the parent to a new round. So barring 361.5, the court had the ability to give mom under 366.3, but certainly didn't have to do so. And based, like I said, on mom's track record, the past was not really the past. Yes, Marlene.
So, on a regular case,
Yes.
you have a legal guardian,
Yes.
grandma, she doesn't want the kids anymore.
Yes.
She files the 388.
Yes.
Court says, fine, I'm gonna terminate.
Yes.
Mom's there. Do we have to file a 388 now to get mom reunification back, or does this allow the court to go back?
Depends on if there's a 387 petition at play.
No 387, because the grandmother voluntarily is
Then yeah,
filing.
you would argue 366.3.
And so automatically, under this case, with all of
I don't like that you put automatically.
Okay.
One, because this is San Francisco, so it's persuasive and not binding.
Okay.
But I do think there is an argument to be made under 366.3 that because we're still in RPP land, notwithstanding the fact that the legal guardianship has been terminated, that the court has to consider return to the parent.
Without a 388, right?
Yeah.
Got it.
Now, you would file a 388 if she wanted HOP. Or are you asking for services?
If you are back in
RPP land.
and you have no permanent plan at that point, doesn't the department have to assess to return
Yes,
to the parent?
always, yes.
And then so we don't have to file the 388,
We
we
don't.
can follow this and make
You would
these
request a
arguments.
contested RPP hearing.
Okay.
Okay. Liam L, I put under this section, but it's a little bit of a hybrid between 361.2 and review hearings. The children were removed from mother. The father told the department at the beginning, I want custody in the long run. ICPC was completed. The father did whatever, menial things were required of his case plan. Visits have been successful. Agency recommended placement with the father. The court did that, and the mother appealed. The mother claimed that the father had not seen the children in 5 years and claimed that she had no contact for him, but father had immediately contacted the agency. He moved out of state after the breakup. The mother refused to let him speak with the children. He did not oppose placement with the grandmother, wanted to build a bond with the children. And so they said basically when we have a parent who comes in at detention or dispo and says, you know what, I can't take the child right now, but I want to down the road, this Court of Appeals said that basically they should be filing a 388. Now what they did in this case to, I think, basically uphold the juvenile court's decision was basically saying in this case it was a harmless omission because there was sufficient evidence establishing that it was in the child's best interest to change the circumstances and send the children to him under 361.2. Armando L. Just recently came out of Merced County, and it's one of those cases where you scratch your head and at some point, thank goodness you practice in LA. The recommendation was to JT, with the father having full custody of the child Armando. The mother asked to contest that JT recommendation, and both the county and the minor's attorney convinced the juvenile court that mom had zero standing to contest that. And the only person that has a right to contest whether or not a case should be terminated under 364 is the minor's attorney.
What?
Yeah. So you can read it, but basically they say no, a parent can request whether or not JT is appropriate in the context of the custody order. Okay, permanency hearing, there weren't a ton of cases. Here, out of San Bernardino County and Ray A.J., basically detriment's not necessary for the juvenile court to deny biological father visits when a guardianship is established. This basically hinges on two things. One, the fact that he's a bio father, and two, that we're dealing with a guardianship. And I'm not really gonna go over it because the slide is so information heavy, but that is out of San Diego. Noah G, oh, I forgot to put the site down. Okay, I'm gonna tell you the site. Noah G is 247 Cal App 4th 1292. 247 Cal App 4th 1292. It just came down in June out of Department 404. And basically it's dealing with the C1B1 exception and whether or not the evidence was sufficient to defeat the termination of parental rights. This one, I have mixed feelings, which we'll get to right away. Okay, I have mixed feelings on this one. The child was placed with the maternal grandmother who was the prospective adoptive parent. The mom basically, she didn't live there, but she might as well have. I mean, she was going over in the morning, combing the child's hair, brushing his teeth, making his breakfast, going with the monitor to drop him off at school, picking him up from school, coming back to the home after, helping him with his homework. The child was hospitalized for about a week. She went to the hospital and sat by the child's bedside. She attended some doctor's appointments. On the weekend, she was with him during the day. She was watching TV with him. And mom testified to all of this. The court, she also stated she hadn't even started her drug program because the question by the county was, well, when do you find time to go to your program? And she said, well, I haven't started that. That was not a good fact for mom. And the Court of Appeal reversed, but they pointed out sort of the history of the case, that the children, this was not the first time. The children had remained with mom, they weren't detained.
Alan,
You mean
Yeah.
you just said reverse, but
Oh.
it's affirmed.
It's affirmed, sorry, it's affirmed. While the children were in mom's custody, she was totally overwhelmed, resulting in a 387 petition being filed. The maternal grandmother, by contrast, had ensured that all the kids were being taken care of, and a couple of them were special needs. And they found that the court could focus on the mother's failure to complete a drug program, since that was the basis for the 300 petition originally. So it's again, factually specific. You may want to read it, but the fact that mom was not doing a drug program was pretty big for the Court of Appeal. Okay, appellate issues. I know you guys don't care, but there are a couple of things that you're going to want to know. In-rate AK, we might as well just call this one, I think you're a jerk, and the Court of Appeal agrees with me. This is a client that we probably all have had, where he shows up for the detention hearing. He's very angry. His newborn has been detained. He's threatened the social worker. The police had to be called to the hospital to remove him. He basically says to the social worker, I'm not doing anything you asked me to do. Told the social worker, and by the way, don't call me. Then father failed. He appeared at detention, didn't come back. The petition was sustained, and he appealed. Of course he did, right? Of course he did. And actually, this was not LA, this was San Bernardino, but the Court of Appeal dismissed it under the disentitlement doctrine, which is something we have not seen in LA. But father, quote, possessed an attitude of contempt to legal orders in the dependency process. His behavior demonstrated an extraordinary and unmitigated pattern of destruction. And as a result of the disentitlement doctrine, they just dismissed his appeal. Like I said, this is San Bernardino, not LA. It's kind of fascinating because we've all dealt with this guy. But let's just call it I think you're a jerk, and the Court of Appeal agrees with me.
So there's a whole running theme of assholes lose.
Oh, yes.
Yeah.
That's why we don't have many great published D cases for parents. The next slide is just some that I didn't even bother to make their own slide. In Ray Albert A, the failure to file a writ petition was excused because the parent wasn't actually notified of their ability to file a writ petition. And then N Ray NS, which has to do with the mootness of an appeal while it's pending. Okay, miscellaneous issues. This is the last section. Okay. Juvenile court erroneously transferred case without considering a minor's best interest. The kids were located in Richmond and San Joaquin County. Marin County is the Court of Appeal. The department up there has a strict policy of transferring cases of relatives. Apparently what happened is these children were related to an employee in Marin County. So the case was supposed to be transferred to Marin County. Marin County looks at it and says, wait a minute, one of our workers is related to this family. Back it goes to Contra Costa. And then mother got mad, and so she appealed. So then on appeal, Marin County says that they have a strict policy of transferring cases of relatives, that this was their sensitive case protocol. The judge remarked that Marin would have to find another county for them if Contra Costa doesn't work. And the department asked to find it moot because the court had already made a reasonable effort to find it. Anyway, it was reversed because, as it turns out, that to the extent the sensitive case protocol authorizes courts to transfer without considering the children's best interest, it's invalid. Because it was just a blanket rule that said, if you're related to anybody that works for this department, your case is not going to be here. And the kids needed services in those counties, and so it was reversed. I did put in a couple cases about AB 12 if you're really interested. There were two published this past year, Andre A and RG. Typically what these appeals have to do with is whether or not the juvenile court had sufficient evidence to terminate a non-minor dependent status. Almost always, all the appeals that are coming out of AB 12 have to do with that issue. So if you have a non-minor dependent case and you're arguing with the department about whether or not their status should be terminated, you can look at some of these AB 12 cases. That's it. I did it and early.
No, it's not a question. My understanding is that there's no such thing in California as horizontal stare decisis. So the decision of one appellate court in California has equal weight as any other.
Really?
Yeah.
See, I've always
It's the
argued that
California
it's...
Supreme Court which decides.
Oh, yeah.
Because even within a district, there can be different divisions of different.
I always argue both.
Don't forget to turn the evaluations over here.